I'm Nevada criminal defense attorney Michael Becker. Under NRS 453.3385, drug trafficking is defined as possessing, selling, manufacturing, or transporting 100 grams or more of certain narcotics. These include 1. Schedule I drugs, not including marijuana. 2. Schedule II drugs. 3. Flunitrazepam, also known as Rohypnol. Or 4. Gamma-hydroxybutyrate, commonly called GHB. Since trafficking involves large amount of drugs, prosecutors typically bring these charges against big-time dealers and drug lords, and defendants face separate charges for each drug they allegedly trafficked. So if a person is selling large amounts of both cocaine and ecstasy, that person would face 2 separate trafficking charges, one for each drug. The penalties for trafficking in Nevada depend on the weight of the drugs. Trafficking 100 to less than 400 grams is called low-level trafficking. This is a Category B felony carrying 2 to 20 years in prison and up to $100,000 in fines. Meanwhile, trafficking 400 grams or more is called high-level trafficking. This is a Category A felony carrying 25 years or life in prison with a possibility of parole after 10 years and up to $500,000 in fines. Although prison is usually mandatory for trafficking convictions, the judge can reduce or suspend the sentence if the defendant helps the police investigate the crime, such as by becoming an informant. Note that trafficking marijuana is a separate crime under NRS 453.339, and the amount of marijuana must amount to at least 50 pounds for trafficking charges to apply. If you're facing a criminal case in Nevada, call my legal team at Las Vegas Defense Group. We'll fight to get your charges reduced or dismissed.